medical care providers who got zonked by the vicissitudes of the insurance business cycle a few years ago. As the stock market was, the bond market was tanking, investment income was disappearing from the balance sheets of our med mal insurers. They had to jack rates, and doctors and hospitals got hurt. Thankfully, we're back to what passes as normal in the marketplace, but we brought Harvey out here so we can share some ideas with our legislators on how to hedge our bets for the future and provide better market regulation to hopefully avoid these problems when they come up next time. So take it away.
Okay. Well, I mean, I'm not exactly sure. I need a little guidance from you guys. I know that we're going to do it one-on-one in a minute. Let me just tell you a little bit about what I did in California. You can prompt me which way you want to go in terms of more information. So, like Iowa in the last few years, California in the 1970s had a huge problem with medical malpractice insurance premiums. These are the premiums that doctors pay to cover themselves against committing medical malpractice. California also had a huge problem in the 1980s on auto insurance where rates were skyrocketing. And as is California's way, we're pretty much a laboratory for democracy. We've tried caps on damage awards, didn't work. And then we've tried really tough regulation of the insurance companies. So that's where I kind of come in. I wrote the law that the voters approved in 1988, which regulates all forms of insurance companies. It required a 20% rate rollback, requires insurance companies to open up their books and justify their premiums before they go into effect. It bans unfair practices in the sale of auto insurance, requires an elected insurance commissioner, and perhaps most importantly, it gives consumers the right to go to court to challenge insurance companies when they break the law, including that law, Prop 103. Because you can have the best laws on the books, like here in Iowa, the laws are okay, they need to be improved, but you can have good laws. If you don't have the ability to enforce them, then you really cannot expect any results at all. And so, as a result of Prop 103, $1.2 billion in rate refund checks were issued by the insurance companies. Another $23 billion in insurance increases were blocked between the passage of the law in 1999, according to a national study. California, between 1989 and 2004, our auto insurance premiums actually went down 7%, and when they went up by about 49% for the rest of the country during that period of time. We've used the law to challenge rate increases that were unfair for doctors and their medical malpractice insurance and save doctors $66 million just in the last 3 years alone. Same thing with auto and homeowner. Just our organization intervening with our lawyers and our experts to challenge the rates and practices of the insurance companies, $800 million in savings. So it's a very tough regulatory system. But and then if I may humbly relate that to Iowa, what's missing here is a similar set of tough laws. For one thing, the insurance commissioner doesn't even have the authority to order refunds if an insurance company overcharges people. And that's very important. That the legislature should pass. There's no right for a consumer to challenge a rate application that's filed by an insurance company. In fact, there's no notice given to the public when those insurance companies file those applications. It's done at the insurance commissioner gets them, has I think 30 days to review them, and then they go into effect. And there's no public participation. So then what would really help in Iowa would be the right for people to intervene, to demand a hearing when an insurance company charges too high rates or engages in an abuse like denying long-term care coverage, which is it's almost an epidemic here in Iowa of long-term care abuses. And another thing that would be good in Iowa would be to have a group of lawyers in the Attorney General's office whose goal is to monitor and challenge insurance rate increases. There is such a group of lawyers that work in the AG's office, I believe, to lower utility rates. And ratepayer advocates like that are common in many states. What's less common is the right of a branch of the Attorney General's office to go in there, examine rate increases or other activities of an insurance company and say, we want to challenge this before the Department of Insurance, or even the right to go to court. I don't know, I've given you a very abbreviated kind of assessment of Iowa, obviously, but if I can tell you specifically more about California, the battle there, the insurance industry, when we wrote 103, when I wrote Proposition 103, that initiative, the insurance industry spent $80 million against it. We spent 2.9 for it, average donation from the public, $10 to our campaign. As I said, it had a huge financial impact on people's pocketbooks. It's the only state in the nation where that's happened. Here's another angle too. California, before 103, like Iowa today, had no antitrust laws that were applicable to the insurance industry. The insurance industry in California had an exemption from the antitrust laws, as it does here in Iowa. So here in Iowa today, insurance companies can literally take their price list of what they're going to charge people and circulate it among themselves, which, if it were any other industry, would be illegal. And that's because they're exempt from the antitrust laws. And so we've repealed that exemption on the theory that that would lead to more competition.
When you were talking about the medical malpractice insurance, a lot of the rural doctors here in the state have said that the rising costs of that has kind of kept them from sometimes being able to practice there in the smaller towns and are having to come up here. Were you seeing the same thing in California?
Yes, the doctors in California, well, let me say it this way, the doctors in Iowa have been the victim of an enormous scam. The same thing happened in the 1970s in California. Insurance companies raised the premiums doctors pay for malpractice coverage. And then when the doctors complain, the insurance companies blame it on lawyers and lawsuits. And as a result, the insurance companies say the solution is to cap lawsuits and cap damage awards and cap attorneys' fees and stop litigation. And we tried that in California in the 1970s. It didn't work. After those caps were put in place, insurance premiums for malpractice went up another 450%. It wasn't until Proposition 103 passed and mandated a rate reduction and regulation of insurance rates that the doctors got the financial relief that they were hoping for. Malpractice premiums went down 20% after Proposition 103 passed and never exceeded the 1989 level until 2001. So the doctors become conscripted by the insurance companies. The white coats become the leaders of the attack on the legal system and on lawyers and in fact on patients, on victims of medical malpractice. When in fact what the doctors should be doing is what we're doing in California. We're intervening to challenge rate increases for doctors. And as I said, we blocked $66 million in rate increases for doctors over the last 4 years, since 2003.
Why doesn't the free market system work in insurance?
Great question. There's a number of reasons. First of all, insurance is one of the only industries in the country where there's legalized discrimination. You cannot go to an insurance company and buy a product at the same price. Everybody gets charged a different price. Some insurance companies won't sell you their product at any price because they think you're too sick or you're too dangerous a driver, whatever it may be. They're allowed to discriminate legally against consumers. Also, they're exempt from the antitrust laws, as we just talked about. Another reason why they're different is the product is extremely complex. It's more complex than the average citizen really can grasp. And those are the main reasons.
Why are they allowed to price fix?
Because they're exempt from the antitrust laws. And then if you ask me why are they exempt, that was done in 1947 after a U.S. Supreme Court ruling that said that the insurance companies were subject to federal antitrust laws except to the extent that they were regulated